Hello friends, I welcome you all in today's lecture. Today I am going to discuss about the voidable marriage under the Hindu Marriage Act. Friends, before starting anything, I want to conclude what we discussed in the last class. In the last class, we focus on the judicial separation and the void marriage. Judicial separation not means divorce. Judicial separation is an alternative remedy in a case of divorce. Therefore, judicial separation is a safety wall which provides you another alternative chance to think and rethink over your drastic step. The ground of judicial separation is given as it is the ground of divorce. Friends, after the judicial separation, the parties of marriage not under the obligations to live with other party and perform the marital obligation. They are free not to perform the marital obligation. Suppose if a decree of section 10 is passed in the favor of one party of marriage, then any court of India cannot pass a decree under section 9 because either party have a reasonable excuse because they already have a decree under section 10. Friends, be careful about the difference between the judicial separation and divorce. Divorce decree may exempt you from any kind of relationship. You will considered alien for each other. You are free for second marriage. But in a case of judicial separation, status still exists. You will considered as husband and wife, and the parties of marriage are not free to remarry so long as they not obtain the decree of divorce. Friends, I also discussed with you that judicial separation and after the separation there is no cohabitation between them, 1 year time has been lapsed, it may also work as a ground of divorce. Friends, in the last class we also discussed about the void marriage. For the purpose of void marriage, ground is given in section 11. Section 5 subclass 1 monogamy, section 5 subclass 2 privated degree, section 5 subclass 5 sapinda relationship. If marriage contravenes these three grounds, then marriage will considered void marriage. In a void marriage, husband and wife have no legal status. But the important point is, friends, if your marriage is void, it not mean that you are free to do anything. If you want to end your relationship, you must present a petition before the court and court finally provides you space to live separate. Formal declaration of court is necessary for the purpose of section 11 because the provision is very clear, friends. On the petition of other party and by the order of court, the court may declare a marriage as a void marriage. We discussed the provisions in the last class. Today I am going to discuss the voidable marriage. Friends, before starting anything, I want to focus on the learning objectives of the today's class. Friends, the learning objectives of the today's class includes first, meaning of voidable marriage, conditions for voidable marriage, the time limits for filing a petition, meaning of impotency, fraud and force. And we also discussed the difference between the void and voidable marriage. Friends, now I want to focus on the voidable marriage. Friends, a marriage which can be annulled or voidable at the option of one or both the parties is known as voidable marriage. One party of marriage may approach the court or both the party of marriage may approach the courts for declaring a marriage null and void. Friends, the provisions related with voidable marriage is given in section 12 of Hindu Marriage Act. Very important is, friends, section 12 is retrospective and prospective itself. Marriage may be solemnized before or after the commencement of the act. In both the cases, parties of the marriage have a right to file a petition under section 12 of the Hindu Marriage Act. Friends, the petition of the annulment of a voidable marriage is maintainable whether the marriage is solemnized before or after the commencement of Hindu Marriage Act. Friends, a voidable marriage remains legally valid and binding in all respect until a court issues a decree of annulment based on any grounds is specified in section 12. When we are going to think about the voidable marriage, we should think about the general idea. Voidable marriage is valid unless and until it is formally declared void by the court. And grounds of voidable marriage is given in section 12, and the remedy which is mentioned in section 12 is available in both the cases whether marriage may be solemnized before or after the commencement of the act. So these are some fundamental and basic observation about the voidable marriage. Friends, now I want to focus on the ground of voidable marriage. The ground of voidable marriage is given in section 12 subclass 1 of the Hindu Marriage Act 1955. Any marriage solemnized whether before or after the commencement of the act shall be voidable and may be annulled by a decree of nullity on the following grounds. The first is that the marriage has not been consummated owing to the impotency of respondent. This ground is known as impotency of respondent, and due to impotency there is no cohabitation between the parties. Second ground is that the marriage is in the contravention of the condition mentioned in section 5 subclass 3. Friends, section 5 subclass 3 is about the mental capacity of the party. Party must be capable to give a valid consent. If the one party is not able to provide valid consent, then on that basis marriage may be declared as voidable. The third ground of the voidable marriage includes the consent of petitioner or the guardian obtained by force and fraud. If the consent either of the petitioner or the guardian obtained by the force and fraud, then the marriage may also be declared as voidable marriage. And the fourth ground is that the respondent was at the time of marriage pregnant by some person other than the petitioner. Pregnancy of respondent other than the petitioner is also a ground of voidable marriage. The voidable marriage includes four grounds. First ground is impotency of the respondent. If there is a contravention of section 5 subclass 3 which is associated with free consent and mental capacity, not unsoundness of mind. Third is consent obtained by petitioner or by guardian of petitioner, where the consent of guardian is required, obtained by force and fraud, then marriage may be declared as null and void. And friends, the fourth is the respondent was pregnant at the time of marriage other than the petitioner is also a ground of voidable marriage. Friends, now I want to focus on the first ground of the voidable marriage, that is impotency. Impotency is a first ground. Impotency of the respondent means he is not capable of having physical relation with the petitioner. Friends, section 12(1)(a) provides impotency as a reason of non-consummation of marriage. So due to the impotency, there is no consummation of marriage. So potency is a reason and non-consummation of marriage is a consequence. Therefore, it becomes a ground of voidable marriage. Friends, a respondent has no capacity to have conjugal intercourse, which is one of the objective of marriage. Therefore, marriage is going to be declared voidable. Because I already told you when I discussed the marriage, dharma prajaratyartho hi vivaha. The purpose of marriage also includes sex and sexual intercourse. If because of impotency, if a person is not entitled to consume the marriage, obviously it is a ground of voidable marriage. Friends, for the purpose of understanding the idea of impotency, we should understand that full and complete penetration is an essential ingredient of ordinary and complete intercourse. Friends, the question is, when we consider that marriage is consummated. Friends, a marriage is consummated by sexual intercourse which consists of penetration by male genital organ into the female genital organ. Friends, the court observed in the case of Summer versus Snigdha that the degree of sexual satisfaction obtained by the parties is irrelevant in order to explain the impotency. Friends, sexual intercourse is one thing, degree of sexual satisfaction after the intercourse is another thing. If sexual intercourse happened, it's sufficient for a marriage, and then no one can proceed for the voidable marriage. Friends, whether penetration exists or not, whether marriage is consummated or not, you may prove this by the medical evidence. Therefore, the perception or the opinion about the satisfaction of either party is not relevant for this purpose. Friends, in a case of Samla Devi versus Surjit Singh, the court observed that potency in a case of males means the power of erection of a male organ accompanied by the discharge of healthy semen containing live sperm. This is the definition given by the court in reference to the potency, friends. But in the case of Digvijay Singh versus Pratap Kumari, the Supreme Court in the year 1970 observed that a party is impotent if his or her marital or physical condition makes consummation of marriage a practically impossible. So the test laid down by the Supreme Court is very practical. A party is impotent if his or her mental and physical condition makes consummation of marriage a practical impossible. So due to this practically impossible, you cannot enter into the sexual relationship. Friends, the ground of impotency is amended in the year 1976 by Marriage Law Amendment Act, and now the provision is, friends, before the amendment, the original provision was that the respondent was impotent at the time of marriage and continued to be so until the institution of the proceeding, friends. Means before the amendment, the section 12 concludes that impotency at the time of marriage and that impotency is still exists before the filing the proceeding. But now the provision is simple. If marriage is not consummated due to the impotency, then it is sufficient for proceeding a case or initiating a case under section 12 for voidable marriage. Friends, now the important point is whether your impotency is curable or not. The point is very clear and simple. Once the petition is made under section 12(1)(a), the curability of impotency is not relevant, friends. It was also not relevant in the old provision, friends. Friends, idea is very clear and simple. If you argue that impotency is curable, you may go through the medical treatment and involved in sexual intercourse and marital intercourse. But once a petition is presented that till today there is no cohabitation due to impotency, then argument before the court about the curability is not admissible, friends. So therefore, no relief will be provided for such kind of impotency under section 12, friends. Now the next question is the proof of impotency. Friends, As you are aware about that, potency and impotency is so personal matters. It revealed in a private and personal interaction. Intercourse is such a secret affair that it is within the exclusive knowledge of the spouse. Friends, therefore, if you are going to prove the potency or impotency of either party of marriage, there is no need of general evidence, because potency is a so personal and so intimate affair. Therefore, there is no chance to produce a general evidence for the proving the impotency, friends. Therefore, rule is very simple and clear. It is the petitioner who has to bear the onus of proving the impotency of the respondent. Friends, suppose if you filed a petition of voidable marriage on the ground of impotency, then you will prove that respondent is impotent. Means whose argued an argument, burden of proof lies on that person to proving the very fact. Friends, non-consummation of marriage proves impotency. If there is no consummation of marriage, obviously it proves impotency. And impotency may also proved by the medical examination. Friends, now I want to focus on the types of impotency. Friends, the first category of impotency may be physical impotency and mental impotency, friends. Friends, impotency may be physical, may be psychological, or may be mental, friends. When we can say that he or she is physically impotent, or he or she is psychologically or mentally impotent. Friends, a person is physically impotent when his or her genital organ is absent, or is either too small or too big, or because of some disease, therefore intercourse cannot be performed by him or her. So due to certain physical reasons, intercourse is not performed by them. This is the example of physical impotency. Friends, generally physical impotency may be cured by surgery and medical treatment, because physical impotency nowadays cured by number of surgery in general, friends. So this is one kind, this is known as physical impotency, means physically due to the structure of the organ they are not able to perform sexual intercourse is physical impotency. The second one is psychological or mental impotency. Friends, psychological and mental impotency includes dislike, hearted for sex due to moral turbo or due to the mental disease. So due to the dislike of either party of marriage, you are not able to perform sexual intercourse with her. Because of your philosophy of life, morality of life, you are unable to perform sexual intercourse with her. Or you are suffering with any kind of mental disease, therefore you are not able to perform sexual intercourse with her. Although you are physically fit but not mentally and psychologically fit, it is also a impotency. This impotency is known as psychological or mental impotency. Friends, for example, a homosexual person may be impotent towards a person of opposite sex, although he is physically fit for intercourse, but because of homosexuality he is not liking male, he is not liking opposite sex. Therefore it comes under the category of psychological impotency. So there may be a combination of both physical and psychological factor contributing to the impotency. So this is the point, friends. Impotency may be physical, may be mental or psychological. Any kind of impotency may exist, but section 12 only focused on consequence, whether consummation of marriage happened or not. If consummation of marriage not happened, it is a ground of the voidable marriage. Friends, now impotency may also be categorized in two categories, general and particular impotency. Friends, general impotency means when impotency is complete, and when we think about the specific impotency means impotency is relative. Friends, how we can explain the idea of general impotency? Impotency is general when a person is unable to perform sexual intercourse with anybody. Means due to your structure, due to your psychological condition, you cannot perform sexual relationship with anyone. And impotency is specific when a person cannot have intercourse with a particular person. In this case also, petitioner is entitled to the decree. Suppose friends, you are physically fit, but you are unfit in the case of your wife. Why? Because you not like your wife, you are thinking something about your wife, therefore you have not in positions to initiate sexual intercourse with your wife. Therefore this impotency is specific impotency, and for the purpose of law, general impotency and specific impotency both is objectionable. Friends, now the point is very simple. Impotency will be categorized general and particular impotency, and physical and mental or psychological impotency. Friends, in the case of Neeta Nijwan versus Balkishan Nijwan, the Delhi High Court in the year 1973 observed that impotency is a lack of ability to perform full and complete sexual intercourse. Imperfect and partial intercourse would not amount to consummation of marriage, and if the husband was incapable of performing the sexual intercourse full in the eye of law, he would deemed be impotent. Friends, so this is the ground which related with the impotency. Impotency is the first ground of the voidable marriage. Impotency may be physical, may be mental. Impotency may be general, may be specific. All kind of impotency may exist, but law only focus on consequence, whether marriage is consummated or not. If the marriage is not consummated, a person may proceed for the voidable marriage. How you can prove the impotency is so specific. Who argued, who will prove? And friends, the impotency may also be proved by medical examination. Friends, now I want to move on the second ground of the voidable marriage, that is the mental unsoundness or mental disorder as mentioned in section 5 subclass 3. Friends, if marriage contravenes with the section 5 subclass 3, then marriage may be declared as voidable marriage, or the court may declare void marriage. Friends, section 5 subclass 2 is very specific about the mental unsoundness and mental disorder. Friends, please recall the lectures of condition of marriage, where we discuss in detail about the mental soundness. Friends, I will also discuss in detail about the mental soundness when I discuss the ground of divorce. Friends, idea of mental soundness is provided in 3 places: condition of Hindu marriage, ground for the voidable marriage, and ground for the divorce. Therefore, friends, when we discuss the idea of mental unsoundness, we think in totality. In which circumstances is contravene section 5 subclass 2 for the condition of marriage, in which circumstances marriage may be voidable, and in which circumstances it may be work as a ground of divorce. But fundamental point is, friends, presence of disease is one thing, consequence of disease another thing. Under the Hindu Marriage Act, disease per se cannot a ground of voidable marriage, not a ground of divorce, not a contravene section 5 subclass 2. Effect of mental unsoundness and mental disorder is very crucial, friends. The point is very simple and clear. If you are not mentally fit for the consent of marriage, then you may approach the court for declaring your marriage null and void. Friends, although you are capable to give valid consent, but you are unable to understand the nature of marriage and obligations thereof, you may also approach the court for void to declare your marriage null and void under section 12 of the Hindu Marriage Act. So therefore, friends, now I want to close the discussion, because you may refer the lecture which I delivered in the condition of Hindu marriage, and which I will deliver when I discuss the condition of divorce, friends. Now I want to focus on the third ground, consent obtained by force and fraud. Friend, under section 12(1)(c), provided the third ground of the voidable marriage when the consent of the petitioner or the consent of the guardian obtained by the force and fraud, then it is a ground of the voidable marriage. Friends, the provision is very simple and clear that the consent of such guardian or consent of petitioner was obtained by force or by fraud as to the nature of ceremony or as to any material fact and circumstances of concerning the respondent. Friends, therefore, if the consent of petitioner or his or her guardian of a marriage is obtained by force or fraud, then it is one of the ground of voidable marriage. Friends, the force or fraud must be in reference to the nature of ceremonies or as to any material fact or circumstances related with respondent. Friends, the rule is that the consent of party concerned must be free. Friends, now I want to summarize my discourse that under section 12 subclass 2 is clear that the conditions related with the force and fraud is not absolute. Why it is not absolute? Because a proviso is given in section 12(2)(a). The court will not entertain the petition in following condition, friends. For example, first is, if the petition is presented more than 1 year after the force has ceased to operate or fraud has been discovered. And the second is, if the petitioner has with his or her full consent lived with other party to the marriage as a husband and wife after the force had ceased to operate or the fraud has been discovered. So friends, the condition is not absolute. In both the circumstances, court is not going to entertain any kind of application which are meant for the voidable marriage in specific circumstances, friends. When you presented your application after the expiry of 1 year, after the force has ceased, fraud has been discovered. And after knowing the force, after knowing the fraud, still you are living as a husband and wife, in both the circumstances, you are not entitled to file a decree of nullity, friends. Friends, now the crucial point is, what is the meaning of force and what is the meaning of fraud? Friends, the term force has not been defined under the Hindu Marriage Act. Force exclude any real or intelligent consent. Friends, force is actually means fear, due to which a person acts even against his or her will. Therefore, friends, in an English case, Chichester versus Chichester, the court observed that if the consent had been obtained by an immediate danger of life, limb or liberty, the consent will be regarded to have been obtained by force. Friends, but we must focus that danger must be subjective and it should be based on reasonable cause. Friends, the consent of fraud may further explained. The consent of force further may explained with different illustration, friends. The force may applied by the respondent or by some other person, including even the near relative of the petitioner, friends. Friends, every inclusion or unpleasant situation of life, for example, disrepute, poverty, displeasure in relationship, cannot be included within the meaning of force, friends. Force means imminent danger to the life. Friends, in the case of Rice versus Rice, a woman was forced to marry a man who sold a pistol to the wife, and it was held that the consent was obtained by force, therefore marriage is void. Friends, in another case, Scott versus Sebright, the bridegroom threatened the bride that if she did not behave well during the marriage ceremony, he would shoot her. This is also considered fraud, force, and therefore consent is not considered free, friends. Friends, in the case of Nand Kishore versus Srimati Munni Bai, the MP High Court held that force and fraud means condition in which there is an absence of real consent. The term fraud had been used in sense of lack of element of consent. Here it is not to be understood in the sense under the section of Indian Contract Act, because contract is different than marriage. Therefore, the term force should not be interpreted in the light of Indian Contract Act. Yes, you may derive certain points on that basis, you may think about that, friends. Friends, now the question is, what is the meaning of fraud? The fraud is not defined under section 12 of Hindu Marriage Act. It is defined in Indian Contract Act, but I already told you that you may draw certain sense related with fraud, but you cannot totally rely on fraud as defined in Indian Contract Act. Friend, very specifically under section 12, fraud must be related with the nature of ceremony of marriage and material fact and circumstances concerning the respondent. Friends, in very important case, Anand Nath versus Lajjavati Devi, the Calcutta High Court and Justice Dutt observed that the marriage include two stages. First stage when the parties agreed to the marriage, and second stage is when the marriage is actually solemnized. The fraud practiced at the first stage does not render the marriage voidable, but the fraud at the second stage, which is material and which makes a marriage voidable. So friends, we should think about the fraud, because fraud is second important ground on which the marriage may be declared null and void under section 12. Friends, now I want to focus on the different examples related with the fraud. Friends, fraud means fraud not on simple fact. Fraud must be practiced on the material fact and circumstances related with nature and respondent, friends. Then the fraud is material, useful for the purpose of voidable marriage. For example, friends, identity of party. A marriage cannot be annulled on the mistake of identity of a party to a marriage under the English law. It comes under the mistake. But friends, under the Hindu law, if one party of marriage not identified actually second party of marriage, then it is the ground of the fraud. For example, friends, two people are agree, husband and wife agreed, but mistake of the identity of the party is the ground of substantial fraud, friends. Friends, the concealment of disease is another ground. Concealment or misrepresentation of the disease of serious nature may also be considered as fraud. For example, disease like HIV and cancer may comes under the purview of fraud, friends. Concealment of the religion or caste. In a case of Bimla versus Shankar Lal, the court held that misrepresentation about the caste was sufficient to entitle the petitioner to get the marriage annulled. Friends, concealment of the pre-marriage status. In Bijender versus Binod, a woman represented that she was graduate and legally divorced, but both were found untrue. It was held that it amount to fraud. Friends, the concealment of unchastity. Unchastity of a girl before the marriage is not ground of annulment of the marriage under the English law and Indian law, friends. But friends, very interesting case is Harbhajan Singh versus Srimati Brij Bala, where assured by the respondent father that the girl was virgin. Through subsequently it was found that she had given birth of a child before the marriage. Therefore, it considered the fraud and marriage was declared void. Friends, I want to clarify that general moral character before the marriage is not relevant after the marriage. But substantial fact that a lady already pregnant before the marriage hide this fact and enter in new marriage, obviously and certainly it is a fact which comes under the category of fraud, friends. Now I want to focus on the fourth ground of the voidable marriage, pregnancy of respondent wife at the time of marriage. As per section 12(1)(d), if the respondent was at the time of marriage pregnant by some person other than the petitioner, then it is one of the grounds of voidable marriage, and this ground is borrowed from English law. Section 12(1)(d) is very clear. The respondent was pregnant at the time of marriage. She was pregnant by a person other than the petitioner, and the petitioner did not know the pregnancy of the respondent at the time of marriage. Now, condition for the petition. Section 12(2)(b) stipulates the prerequisites condition for filing the petition under section 12(1)(d). The court will entertain a petition on the grounds of premarital pregnancy only being satisfied on the following facts. First, that the petitioner was at the time of marriage ignorant of the fact alleged. And second, the proceeding have been initiated in a case of marriage solemnized before the commencement of this act within 1 year from the such commencement, and in a case of marriage solemnized after such commencement within 1 year from the date of marriage. Friends, the next ground is that marital intercourse with the consent of petitioner has not taken place since the discovery by the petitioner of the existence of the said ground. In appropriate fact and circumstances, an application under this section may be converted into the divorce. Friends, the point is very clear. Suppose pregnancy exists before the marriage, then it is obligatory for other party that party must be ignorant about this fact. If marriage solemnized before the commencement of this act, petition must be filed within 1 year from the date of commencement, friends. And if marriage solemnized after the commencement of this act, then petition must be presented within 1 year from the date of marriage. And there is no sexual intercourse between husband and wife after the recovery of this fact, then it will considered as ground of the voidable marriage. Friends, in a case of Mahendra versus Susila, Supreme Court observed that where the wife admitted her pregnancy from before the solemnization of marriage, despite not having met her husband, the situation falls under section 21D and husband is entitled to get divorce uh, to a decree of nullity on the ground of section 12. Friends, now I completed my discourse on the voidable marriage. Now just I want to focus on the difference between the void marriage and voidable marriage. Void marriage means non-fulfillment of any condition of section 11 renders a marriage null and void from its inception. Voidable marriage, marriage is valid till the decree of nullity of marriage. Void marriage, either party to such marriage can obtain the decree of nullity of marriage. In voidable marriage, only a aggrieved party may file the petition for the nullity of marriage under section 12. Where one of the conditions of section 11 is present in a marriage can not be declared void. Voidable marriage is the violation of condition under section 12, and section 11 has prospective effect, means marriage must be solemnized after the commencement of this act. But if you want to remedy under section 12, marriage may be solemnized before or after the commencement of the act, friends. So this is the difference between the void and voidable marriage. The idea is very simple and clear. Void marriage is void ab initio. Voidable marriage means voidable after the declaration of court. So long as the marriage is valid, everyone is good. But in the case of void marriage, the wife may be denied from certain rights, friends. Now I want to conclude my discourse, and therefore, friends, you may think about this. How does the concept of voidable marriage balance indivisible rights with societal expectation? Are the legal consequence of voidable and void marriage are same? How is a voidable marriage different from a void marriage? By this discussion, I am concluding my entire discourse related with the voidable marriage. Section 12 laid down the criteria for the voidable marriage. It includes 4 grounds. The grounds includes impotency, unsoundness of mind, force and fraud, and consent obtained by force and fraud. And the fourth is pregnancy before the marriage. These are the grounds for voidable marriage. But the ground of last 2 grounds are not absolute. You are bound with section 12 subclass 2. After fulfilling the condition of section 12 subclass 2, petition may be accepted by the court. Therefore, they are not absolute. But friends, we must be careful about the difference between the void marriage and voidable marriage, which I discuss with you, friends. This is the entire concept of the voidable marriage under the Hindu Marriage Act. Thank you, friends.